Oh na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Big it up. Oh na 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 na. Big it up. Oh na 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 na. Bam bam. Bir bam bam bir bam bir de. Bir bam bam. Bir bam bir de. Bir bam bam bir bam bam bir bam bir de. Bir bam bam. Bir bam bir bam 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 bam. Bir bam bir de. Bir bam bam.
Welcome everyone to Home and Away Jamaica, where we connect Jamaica with the diaspora and also Jamaica with Jamaica. Welcome. I am Robert Taylor, your host, attorney at law, and with me today is Stacey Salmon. Stacey is managing partner of Taylor Law. Stacey, welcome. Happy to have you again with us.
Thanks again for having me.
Stacey, we always invite you when we're dealing with some very specific issues, and today is no exception. What we want to do today is discuss the agreement for sale or the contract for sale. The agreement or contract for sale of land, sale of house, is generally, most often than not, handled by the attorney representing a purchaser or seller in a transaction. And many persons may not be aware of the intricate clauses, the different provisions that are in that agreement. So, I think it's a good thing for us to, in the time we have today, to discuss the agreement for sale. We know under the statutes of fraud, all negotiations, all sale of land must be in writing. And so the customary transaction document is that contract for sale. So Stacey, we know many persons where they're using a realtor, they may have an offer to purchase, which is really a form setting out the details of the real estate being acquired, as well as both the person selling and the person buying their details. We know that certainly in Jamaica, in our jurisdiction, is not legally binding, and the parties are not bound until the contract for sale is signed. What I want to ask you to do today is share with us, when you're representing a purchaser and a seller, what are some of the things that you look out for in a contract? So if you're drafting on behalf of a seller, share with us some of the provisions that you make sure are included in that contract.
All right. So as you said, the agreement for sale is the legal document that sets out the terms and conditions of the sale. So whether I'm representing the vendor or the purchaser, there are always certain things that I look out for. First thing, ensure that the parties' names are spelled correctly. Next, I look to ensure that the description on the title is consistent with the description that's in the agreement for sale. So the name of the property, the parish, and the volume and folio that's set out on the title must be consistent with what is set out in the agreement for sale. The purchase price is also something that I look out for. So the agreed purchase price that would be set out in the offer to purchase form that would have been signed by both the vendor and the purchaser. The agreed deposit. So typically we'll see a deposit of 10% of the sale price. In recent times, with the change in the law in Jamaica, the transfer tax and stamp duty have been reduced. So the purpose of the deposit is to ensure that the vendor is able to cover the payment of transfer tax and stamp duty. So we've seen the request for the deposit to be reduced to as low as 5%. So I ensure that whatever was agreed on under the offer to purchase form is reflected in the sale agreement. And also the balance due on completion. Let's trying to think. All right, also the possession. So whether or not the vendor is to hand over vacant possession, meaning that there are no tenants or occupants on the property. Or vice versa, the purchaser may have agreed to take the property with the tenants on the property. Also look out for whether it's a cash or a mortgage. So whether the sale is subject to a mortgage. So if the sale is subject to a mortgage, there's certain timelines that the purchaser must meet. For example, when their letter of undertaking from their bank for the balance to close, the balance purchase price is due to close. I'd ensure that the purchaser can meet that deadline. All right, so those are, whether or not I'm representing a vendor or purchaser, those are the items that I would look out for. Now, when I'm representing a purchaser, when I'm representing the purchaser, the agreement for sale is prepared by the attorney with carriage of sale. And this is the attorney that represents the seller. So the seller will send us the agreement, and I would review the agreement to ensure that the terms are favorable towards the purchaser. So I'd ensure that, well, first and foremost, review the title to ensure that the seller is in fact registered on title, so they're able to pass their interest to the purchaser lawfully. Also look out for any encumbrances on title. So this would be whether there's a mortgage, whether there is a caveat, whether there are any restrictive covenants that would prevent the purchaser from, building or extend, putting an right. Let me see. The interest rate is also of note here. So a standard clause in agreements for sale, it provides for the vendor to charge the purchaser interest for late payment. So as I stated earlier, the agreement sets out certain timelines that the purchaser must adhere to. And in the event that the purchaser fails to meet these certain deadlines, the clause entitles the vendor to charge the purchaser interest from the date that payment should have been made to the date payment is actually made. So the interest rate, it's important to ensure that the purchaser would be able to meet the requirement in the event that he's unable to close in the time specified in the agreement. So interest rates have been trending down. So anything below 8%, I would agree to if I'm representing a purchaser. In some agreements, for cash sales, the vendor may include a clause that allows him to retain the purchaser's deposit in the event of cancellation on the part of the purchaser. This is something that I always ask to be deleted from the agreement. So in the event that the purchaser has to cancel, or if he's just unsuccessful in completing, his deposit would be refunded to him.
We would establish and let our viewers know that in law, the vendor is entitled to, provided the parties agree, the forfeiture of a deposit where an agreement is canceled.
Right, that is correct.
But we resist it,
particularly
in the circumstances of residential sales, where we know many persons just putting together that deposit. The sums may be borrowed from friends or family, and it could, really be financially catastrophic to forfeit a deposit. So it's something that, as you've said, is typically resisted.
Right, that's correct.
Okay.
What's also important is to ensure that the purchaser is given adequate time. The standard time is 21 days to obtain a surveyor's report. So what the surveyor's report will reveal, it will reveal if there are any breaches of restrictive covenant or encroachments on the property. So if it is revealed that there are breaches or encroachments, there should be a clause in the agreement to allow the purchaser to provide the vendor's attorney with the surveyor's report within that specified time, to ensure, well, not to ensure, but to give the vendor the opportunity to remedy these breaches or encroachments before the property is transferred to the purchaser.
Stacey, while you're on that point, I had a client ask me, or a client who was under the impression that he could not sell. He was aware of a breach, but he was trying to have the breach cured before he sold the property. And I explained to him that wasn't necessarily required. Can you explain to our viewers what happens when a breach is discovered at the beginning of a sale, and if it affects the sale, and what measures are taken?
All right, so if a breach is detected prior to the sale, the owner doesn't necessarily have to remedy the breach. What his attorney can do is issue a letter of undertaking to make an application to the court to modify the covenant that's on title so that there will no longer be a breach.
So that allows the sale to continue. It's
Right.
very likely that the breach will be amended or modified sometime after the sale, but the mortgage institution or the attorney representing a purchaser will accept an undertaking from the person selling, or the attorney representing the seller, which effectively says, we irrevocably undertake to cure or modify this breach. It may not happen now, but it will happen sometime in the future, and you'll be provided with perfect title. Right.
And usually the mortgage institution will withhold a certain amount of money from the mortgage proceeds until the modification has been done.
Okay. Well, I think we went through quite a number of things in the time we have, Stacey, but very important. We know these things happen behind the scenes. There are a number of issues we contend with when we're managing a sale on behalf of either the vendor or purchaser. And so I think it was very important for us to give some very brief highlights on some of the things that occur. Maybe when we meet the next time, we can probably go more into detail into one of those, a survey, the importance of the survey, or perhaps the importance of, or how caveats are managed. Many times we encounter sales with caveats that have been lodged on the title. So thanks, Stacey. Very thorough. Thanks for your enlightenment. And until next time, it's Robert Taylor and Stacey Salmon, Home and Away, Jamaica. See you soon. Bye-bye.
Bam, bam.